What's going on, y'all? So I received a motion from BRONX Honda today, right? And before I get into this motion, I want to touch on a couple of other things. So y'all know I had a court date for this case, April 22nd, 2026, a couple of days ago, and the hearing was uploaded, right? So the court appearance prior to April 22nd, 2026 was September 3rd, 2025, right? And the defendant didn't appear on September 3rd, 2025. And that was a default. So, what I'm trying to point out here is that this motion right here that I filed for a default judgment, which is April 24th, 2 days after the court appearance, right? I filed this, and all of a sudden now there's a notice of motion to dismiss. You feel what I'm saying? So, and you can see that this case been going on for a long time. The index number is 2024, in the year 2024. It says it right here too, 2024. This case been going on for a while. So, the last court date, like I said, was September 3rd. You didn't file no motion from September 3rd up until now. You had all of that time to file motions and all of that. You didn't do that. You know what I'm saying? You file it now. I get it yesterday and it's dated. I get it today and it's dated April 24th. And the only reason why you're filing this is because of this default judgment motion. You feel what I'm saying? And you got the right to do what you want. But I'm going to show y'all how this is how you could clearly see that I'm in the right. You feel what I'm saying? Because, like I said, you don't file no motions, no nothing until I file my default judgment motion. Now you want to come with this motion. And the motion is frivolous and baseless. You feel what I'm saying? It don't even set grounds for the motion. So let's get into the motion real quick. So this motion right here says, pursuant to CPLR 3211 and 2, for such other and further relief as this court may deem just and proper. So she said, 1, dismissing this action pursuant to CPL, and 2, for such other and further relief as this court may deem just and proper. Where is the grounds for the dismissal? Like I said, she said, number 1, I want to dismiss this action pursuant to CPLR 3211. Okay, on what grounds though? And then 2, for such other and further relief as this court may deem just and proper. You're not stating no reason why you want this case dismissed. No grounds. So, I'm just like, and then she's stating that she's an attorney. You feel what I'm saying? She's not an attorney. But let's move forward. Let's move to the next page. Then, look, what I want to also mention is that this is how you know she's not an attorney. Attorneys don't send motions with a paperclip on a paper. They don't do that. That's something that pro se people do like me. Put paper clips and stuff on there. All my motions got a staple in them. All my motions that I received from the other party are stapled. It just shows that she's not an attorney. An attorney don't move like this. An attorney, they might do something stupid like this, but they're not going to put a paper clip up there. Let's just move forward, right? So then, also, an attorney knows that an affirmation of service is the last page of the motion, not the second page. The second page is supposed to be the affirmation in support of the motion, not an affidavit, not an affirmation of service. And the reason why she's putting this affirmation of service as the second page is because she's putting emphasis on there, because this is not her address. She want me to see this clear as day. I would assume. You feel what I'm saying? So now she's saying, Marcy Jacob, an attorney. You're an attorney now. All right, you're saying this is my address, 1771 Post Road East, whatever. So Westport, that's a whole nother state, I believe. But pull up the address, y'all, and see what comes up. I think it's a pharmacy or something like that. And they might, hold papers there or have a mailbox paper. This is not her address, man. And it says, I'm over the age of 18 and I'm not a party to the instant action. You're not a party to it? You're not? So why in your answer right here, this is supposed to be her answer, which we're going to tap into this, but I just want to show that It says Marcy Jacob being duly sworn deposed and said, I am the defendant in the proceeding. So you were a defendant on September 5th, 2024, but now in April, you're not even a part of this action. You feel what I'm saying? You're an attorney now, and you're not a party to the instant action. You are a party. You feel what I'm saying? And then you saying under the penalties of perjury, you're committing perjury, all right? Then it says, I was also the dealer principal of BRONX Honda. Okay, let's move forward, right? So now it says, this matter stems from a civil court pro se matter filed with the court on August 16, 2024. An answer was filed on September 5th, 2024. So let's go back to her answer, what I was just talking about. September 5th, 2024. We see it stamped. This is your answer, right? But the verification must be notarized. Why is there an X there? The fact that you didn't notarize this verification, it makes your answer null and void. And the reason why this verification must be notarized is because the defendant is being accused of fraud. When you're being accused of fraud, the verification must be notarized. And even if you're not being accused of fraud, I believe the verification was supposed to be notarized. But being accused of fraud, yeah. If I'm saying the APR was raised and you made me put all this money down, that's fraud. And that's what I got as one of my claims anyway. So, yeah, like it must be notarized. Like, so technically there's no answer. And it should have been a default motion for that reason. And I told the clerks when this happened on September 5th, I said, this is not an answer because it's not notarized. And they said, it is an answer. Like, we not allowing you to file a request. I was trying to file a request for inquest. They said, we're not allowing you because this is an answer. You feel what I'm saying? So you can see that the courts was with it. But let's get back to the motion. So down here it says, these APRs are determined by the banks that were the lien holders of the sold vehicles. And those APRs were based on the customer's credit report. It should be noted that BRONX Honda has nothing to do with the approval of financial retail's determination of APR. All right. BRONX Honda has its own bank. I believe that's the only dealership with its own bank. And if it's not, it don't even matter. But BRONX Honda has its own bank. That's the moral. And it's called Honda Financial Services. And yes, I believe they're the only dealership with a bank that's a part of the dealership. They don't have to go out and they don't have to shop around with other banks. If they choose to, they can, but they don't have to. They could just go to their bank. They have their own bank. But she's making it seem like it was determined by the banks. Sounds like other banks. You gotta be kidding me, man. Now down here, it says on December 20th, Mr. Terrell was approved by American Honda Financial Corporation. Honda Finance. Yeah, Honda Financial Services. Exactly. So you make it seem like it's other bank. And it says the vehicle total price was $35,499. Now, the MSRP of the car is $31,000. So I feel like that's the total price of the car. You feel what I'm saying? The taxes, which was $4,000, make it $35,499. And I just wanted to put that out there. It might not be a strong argument, but I just wanted to put it out there just in case, the numbers are incorrect. You feel what I'm saying? Because you see, when you listen to the hearing on April 22nd, 2026, you hear her saying I put $7,000 down when I put $10,000 down. You see, so that's why I want to point out all of these numbers. And look, it says Terrell's down payment was $10,000 plus $1,000 IOU. That was a promissory note, they told me. They even told me to, give them an extra $1,000 for a promise, and they're going to give me a promissory note or whatever. So, you just got to pay attention to these numbers. The MSRP on a Honda Accord, a 2022, is $31,000. And then the $4,000 for tax make it that number. So maybe she's right, but I think the total price of the car, the total price of the car is the MSRP of the manager sell retail price. So, she just tried to mess up with these numbers. Then it says, and the total amount of payments were all clearly spelled out in the Federal Truth in Lending. Right. I think that's the federal law that you violated. You feel what I'm saying? Is the Truth in Lending Act. That's the one that you violated. We're going to tap into all of that though. So let's look at the paperwork that she filed with this motion. This is all the paperwork that shows. This is the contract and stuff, or the contract. So you can just see everything. You know, you can see what I put down and all of that. And then the rest of this, you can't even see. It's like the ink faded away on the rest of the pages. These are the most important probably. But, you know, we'll get to the bottom of it. I just want to show y'all. This is just crazy. This is just crazy. You know what I'm saying? You don't see anything. I don't see anything, man. I see some signatures down here. So anyway, there's some other stuff I want to point out in this motion, right? So, like I said, she didn't even state. When you pull up CPLR 32, yeah, let's get into that real quick. 3211. That's what I want to get into real quick. So look at, I'll put this on my phone, right? CPLR 3211 is a New York procedural rule allowing a party to move for dismissal of a complaint or a specific cause of action early in a lawsuit. This is not early in a lawsuit. We in 2026. You see, the case is from 2024. This is not early. This is 2 years later that you're filing this. It's supposed to be early in the lawsuit. And then it says common grounds include lack of jurisdiction. And y'all can read the rest. She's not stating none of this. The key grounds for dismissal of 3211. You see all the key grounds? All of this. She's not stating none of this. She's not stating none of this, y'all. Personal jurisdiction, all of that. You know what I'm saying? That's number 4. Then you got number 5. You got 6. You got 5, 7, 8. All of this. And she's not stating any of it. You feel what I'm saying? She's not stating any of this in her motion. She's not stating nothing. This is completely vague. You feel what I'm saying? So you didn't even state a ground for dismissal. So why would I even... Oh my God. The next thing I want to point out is... All right. I was also the dealer principal of BRONX Honda. The dealer principal. So we want to look up... what she did. You know, I pulled up her name just to see what she do. You feel what I'm saying? And give me a second. I pulled it up and I want to show y'all something. All right. So yeah, I pulled up her name right here. Googled it. It says no. I asked them a question, whatever. Don't even matter what it says. No, Marcy Jacob was not the general. Yeah, I asked them was she's the general manager. She was not the general manager for BRONX Honda. She served as the chief compliance officer and held position as the dealer principal. Y'all could read all of that. You feel what I'm saying? Around 20 to help manage the dealership founded by her father. You feel what I'm saying? He was listed as the general manager, right? Key details regarding Marcy Jacob in BRONX Honda. Appointed as the chief compliance officer in June 2020 to implement a new strategic vision and culture. Vice president of private legal practice. Okay, identified. Okay, the part I want to point out is you know, former vice president. She took over management role. Here you go. Context. She took over a management role in the family-owned business following federal discrimination charges against the dealership in May of 2020, and I believe that's the lawsuit I'm talking about. At the court appearance on April 22nd, 2026. And y'all can just pull up lawsuit against BRONX Honda. Yeah, that's it. That's what I was talking about at the court appearance. The hearing is uploaded. You feel what I'm saying? So she took over a management role. You feel what I'm saying? She took over a management role. So what is she talking about? Now we got to look up what a chief compliance officer is. This is what she did. This is her role. A chief compliance officer at a dealership is a senior executive responsible for ensuring the business adhered to legal, ethical, and regulatory standards, protecting it from lawsuits and fines. They oversee finance and insurance practices, update federal and state compliance protocols, and train staff to prevent identity theft and ensure truth in lending. There we go with truth in lending. Key responsibilities and usage examples. Regulatory compliances, Fair Trade Commission, compliance with, you know, Fair Trading Commission, yeah, and that's the federal rule that she violated, you know, but this is her role. Like she it says her responsibility is dealing with Federal and Trade Commission regulations. You see that? Then it says updating procedures. I didn't want to read that. And it says educating sales. It says staff training, educating sales and staff on required disclosure, advertisement laws, and fair lending practices. All right, let's go to the other one. Ordering and monitoring, reviewing deals to ensure compliance with state and federal regulations, preventing discrimination in lending. You're a defendant. I don't know, man. You're a defendant, it looks like to me. You feel what I'm saying? I mean, you are a party to the action. You are a party, and you're saying you're not a party. You are. Your role right here, you can be held responsible. You got the answer for what was done. You feel what I'm saying? Then it says investigating misconduct. Your role entails acting as a contact point for customer complaints and investigating potential wrongdoing, such as fraud in the F&I office. So, you the one that deals with fraud and all of that. You feel what I'm saying? With customer complaints and all of that. How are you not a party to this action? How are you? Then it says a CCO might stop a marketing campaign that violates state order, and they might review for customer complaints regarding. Okay, so that's about it, y'all. And I'm just like, yo, this is crazy, man. The only reason why she filed this motion, y'all, is because I filed the default judgment. And that's all I want to point out here. And it was something else. Oh, she's making a court date for June 8th, 2026 at 9:30. June 8th. Okay. Yeah, man. So I think that's about it, y'all. That's about it. So I'm going to holler. I'm trying to think. Was there anything I forgot? No, that's about it. Yeah, y'all. I'm going to holler. Later.